I'm working on an article right now called Judging the Flood of Litigation. And this came about, it's a little bit of a funny story. So basically, a year ago, I was looking at a court opinion, and a few pages in, the court starts talking about a floodgates argument. These are arguments you see pretty frequently. Basically, the court says, well, we're nervous to consider the following approach because if we do so, we're going to open up the floodgates of litigation. Basically, meaning they're worried you're going to have a ton of new claims coming into the courts. I started thinking a little more about it, and I thought, well, wait a second. I mean, really what the argument behind this suggests, whether or not this person can proceed with their claim is based in part on how many other people we think might similarly bring a claim like this, next year or the year after. And that just kind of struck me as really funny, right? We like to say there's equal protection under the law. This is something, in fact, the Supreme Court says, on its building. And yet this basically says that whether or not you're going to get the law's protection might actually depend in part on how many more people are going to come through that courthouse door. What I found was that the court sometimes is worried about protecting itself. We don't want the lower courts flooded. But oftentimes it's worried about another branch of government or another court system. So for example, you'll have cases sometimes where the court will say, if we recognize this claim, we're going to have a huge number of cases coming in. And this can't be right because we're trying to interpret a particular statute, and Congress wouldn't have wanted this. So the argument isn't so much that we're worried about the number of cases, it's more that this gives us evidence that that particular reading would be inconsistent with legislative intent, right? You see a fair number of those cases. So that's already just a very different kind of floodgates argument. You then have other cases. A great example is the Grable case, where the court says, look, what we're worried about here is if we recognize a particular right, we're then going to be bringing in a lot of cases that would otherwise be in state court, and then they're kind of going to come into federal court. And the concern there is that we're going to upset the state and federal court balance. So that's really like a federalism concern. It's not, again, so much about, we're going to have a lot more work for our courts. It's more, we have this particular balance that we've struck between the federal and state court systems, and it's not appropriate for us to be just taking a bunch of their cases and bringing them to us, or vice versa. Okay, so again, it's a different kind of floodgates argument. And then finally, just looking at other regarding kind of floodgate arguments, as I call them, you see the court being worried about the executive, right? So the case that came up, when Bill Clinton was sued, and there was a question about could the current president kind of have a civil lawsuit. One of the concerns there was, okay, we need to be careful here because we don't want a sitting president having a flood of cases coming in, taking up all of his time, and then he can't actually fulfill his roles. But the final part of the paper really wrestles with what I call the kind of self-regarding floodgates arguments, where the court is really protecting its own docket. And when I say that, I don't mean so much the Supreme Court's docket. Of course, they have certiorari, they can decide how many cases they're going to take, but they, really being worried about the lower courts. And basically my conclusion there is I just think those arguments are on shakier ground. It's not clear where the court has the authority to say, we just are worried, that the lower courts the volume of the cases is just too high, so we're going to just not recognize this particular cause of action. And so the conclusion there is that, we really should see the court relying on other mechanisms, changing the rules of federal procedure or changing the federal rules of appellate procedure, doing other things to make sure that we're getting fewer cases in if that's really the concern, but not actually changing substantive law to reach that outcome.